Okay, we'll get started. Thanks everyone for joining us for this webinar. It's part of the Indiana SHRM webinar series. This one is on the Indiana Religious Freedom Restoration Act. No doubt everyone has heard about this, and it's quite a hot topic, obviously. We're going to be recording this webinar, and it'll be on the website indianashrm.org as soon as I can get it translated over and uploaded. On your screen are a few dates that we'd like you to know about. On this Friday, we have another webinar. It's on social media, and it's at indianashrm.org is how you register. Our early bird deadline for HR Indiana 2015 is Friday, May 1st, and also, of course, the dates for the conference are listed there as well. If you have questions for Chris Schrader, our presenter today, please type them in the question box, and I'll get to them at the end of the presentation. Again, this will be available on the website, and also at the end of the webinar, I'll be sending you your certifications for HRCI and for the new SHRM certification. I'm Mark Records. I'm your Indiana State Council Administrator and also the Conference Coordinator for HR Indiana Conference. And it's my pleasure to introduce Chris Schrader. He's our Indiana State Council Director of Government Affairs and also President of Schrader and Associates. And I'm going to give him the screen right now. And Chris, take it away.
Okay, let me get my PowerPoint up here. There we go. Okay. Let's see, close conference windows. All right. Can everybody see my screen now, Mark?
I cannot see your PowerPoint.
Okay. What do I need to do here? Show my screen.
There you go.
Is that better?
No, I don't see it yet. There it is.
Okay, very good. Does everybody else have visibility now then?
They do, yes.
Okay, very
They're
good.
not able to say anything.
Excellent. All right, well, thank you very much. All right, everyone, thank you so much for attending today's session. I'll do the best I can to pull this in with a hard stop at 10 a.m. I'd like to go ahead and start and tell everyone that if you had asked me to place a bet, not on the Final Four, but asked me to place a bet on whether in this Indiana General Session where they're doing a budget that we would have ended up with, in human resources, dealing with 2 additional protected classes, I would have told you there's absolutely no way. I would have put no money on that, and yet that's exactly where we are. So let's look at the agenda here this morning. What should we as human resource practitioners do right now? What's the big headline for us? And it's very difficult to understand things that have happened in a possible vacuum, and I can completely understand how people may not have enough information to put what happened in a reasonable context to understand it, so I'll cover that, as well as the Supreme Court decisions that put us in this spot, and finally give you an idea of RFRAs across the nation, what ours is in typical cases. So we'll go ahead and scoop through that. So right now, I think we need to do this. We know how to do this. We are HR professionals. We have been handling religion in our companies and dealing with the issues of personal and private beliefs and how those are managed in the workplace for a long, long time. We are the pros at this. And you see one of my favorite poems over here to the left, Rudyard Kipling. It's my favorite for this passage right here. And I've learned to discipline myself over my career that when everything is on fire, when everybody is flipping out, that is the time for me to keep my head, to calm down, and to work through what's happening. And I think that, quite frankly, is a good mantra for human resources in general, and I'm sure many of you do the very same thing. So the big headline, sexual orientation and gender identity are now protected classes in the state of Indiana with regards to terms and conditions of employment for all employers. As you read through that act, you'll see that. That is the creation of the 2 new protected classes. Now, those of you who were in locales that already had ordinances of certain types, and not all of them protected employment. So I'm thinking here of Bloomington, West Lafayette, Evansville, Indianapolis. Practitioners in those locales probably have more familiarity with this, but this is new territory for the rest of the practitioners in terms of a new protected class. So let's go ahead and look at the other states in the nation and kind of where they sit. And I understand this is a bit of a busy map, but the color coding over here ought to help. So for point of reference, this deep purple that you see in Washington, Oregon, and California, they're off on the West Coast. That is where you have sexual orientation and gender identity in all aspects of employment. And so Indiana, which previously had only offered that protection to state employees, Indiana is now going to become a purple state in that regard. You see that there's been action in a number of states, whereas throughout the South and much of the West, I should say the Midwest geographically, not Big Ten Midwest, you can see North Dakota, South Dakota, Nebraska, Kansas, all through that mark there don't have any explicit protections. So here is a good idea of being able to understand at a macro level where other states are. And I thought this was important because with all the screaming that was going on, you'd think we were the only people that were dealing with this type of issue. Others have, and this is where they sit today. And I think, quite frankly, this is evolving. Over time, I think we will continue to see more changes, but this is where they sit, and this is what the change will be for Indiana. So how did we get here? I really thought that I had seen some pretty big protests at Right to Work, which was the last bill I was really heavily involved in. And these weren't the crowds of the size for that relatively inside the State House. But when you consider the fact that these materialized very, very quickly, the Right to Work battle, everybody could see coming, and the labor forces were well prepared, and their logistics were laid out. What happened to us, what you see here, was just spontaneous, and therefore it really stands out larger in my mind. So how did we land in this spot? If the session didn't start with this end in mind by any stretch. So let's look back a little bit and get some context here. And this really goes back to a case in the late 80s, Employment Division of Oregon v. Smith. And so in this particular case, Alfred Smith and Galen Black, as you can see here, were Native Americans. And the most important thing here is that they were drug counselors for ADAPT, which was an agency helping people who were trying to beat addiction. And ADAPT, like many similar type organizations, oftentimes hire former addicts to be counselors because they've been through it, they're authentic in dealing with their clients, and so far highly prized. But ADAPT, like everybody else, didn't forget that they'd actually been addicts, and so they did periodic drug testing, and both of these guys tested positive for peyote, which is an extraordinarily powerful drug. And so they were terminated from their jobs as drug counselors. I think we would all agree that's probably the proper action to take. However, Oregon's law, very, very similar to Indiana's, has a challenge for people who have been fired for cause, and that's very, very difficult to get unemployment benefits against that backdrop. And so Oregon then turned around and said, no, you were fired for cause, and so you're denied unemployment benefits. And so the case here was really not about them being terminated from employment. Nobody seemed to have a real problem with that. It was the unemployment benefits that were denied that were the issue. So this goes to the Supreme Court. And the thing that was interesting here is that up to the point in time this decision was made, there had been a 30-year understanding that when a case rolled into a state court that involved exercise of religion, that the test applied to that was to be strict scrutiny. meaning that the state's action was going to fall under a high level of scrutiny, was going to get a lot of attention, and the implication that there was going to be a significant test to be passed and a pretty high bar to overcome for the state to abridge an individual's practice of religion as protected and enshrined in the First Amendment. And so what the court did here was basically blow that construct up. For all intents and purposes, and this is, I'm not offering opinion here, I'm offering fact. The court draws this distinction where they say, okay, you have the power to do it, but Oregon's law was a general prohibition on all of its citizens rather. It didn't target the church, and so therefore it was neutral and enforceable. And so here you can see the majority on that, and Scalia, bolded there, wrote the opinion. Well, Blackmun writes the opinion for the dissent, and he writes this fiery, compelling opinion, dissident opinion that just eviscerates the majority in really material ways, and it becomes a rallying cry at the time. And so Congress then gets involved, right? Because as we know, in our system of divided power, Supreme Court interprets law. It is the legislature that crafts those laws to be interpreted, and so Congress hops in. So in the House of Representatives, the Democrats in particular, and they are in the majority at this time in the House, they absolutely go bonkers. And Charles Schumer, who was then a representative from New York, he was not yet senator, he introduces the Religious Freedom Restoration Act in March of '93. Now these dates you're going to see here are important, and I'll get to it at the end as to why. He then secures 122 co-sponsors. Nobody from Indiana hops on this. And interestingly, he secures both Gary Studds and Barney Frank of Massachusetts, the first two openly gay representatives in the U.S. Congress. Gary was actually first. Barney followed. Barney is now a senator from Massachusetts. Republicans were divided. A lot of them opposed it. They said, okay, the court has said states can have their own religious protection laws, so let the states solve this. We don't need to do anything. But you have a minority in there, a fairly large minority, that says, hey, wait a minute, this can actually reinforce religious liberty. This isn't a bad thing. And so they get 47 ARCO sponsors at the end, which is not a ton for that delegation, but not insignificant by any stretch. Again, none from Indiana. So the takeaway here, whether you were a Democrat or Republican from Indiana, you clearly didn't think a whole lot of this bill. You know, when the herd is moving, the easiest thing for a representative to do is slap their name to co-sponsor a bill that they think is going to pass. So it was telling to me that nobody from Indiana did that, and reinforced to me once again the independence that we often see from Hoosiers in the legislature. The bill passes the House. Now here's the interesting thing. Speaker Tom Foley of Washington called for a voice vote. Those are not overwhelmingly common. They certainly happen. But you'd think on something like this, with so much support, you would actually want a vote taken, a vote tallied, so that you could then run on that, so you could then step out and say to people, you know, here's the record of my vote, here's what I did. And so there's no record of those votes. We really don't know how those people voted in the House. So then it goes to the Senate, and Teddy Kennedy sponsors the Senate bill, and Dianne Feinstein, who was in a very junior, well actually she was a senior citizen, but Barbara Boxer was already in there. Yeah, Dianne Feinstein hops onto that, and the liberal lions of the Senate here, you have Boxer and Harkin, Reed, Kerry, Russ Feingold, everybody hops onto this thing. They make very minor changes, and they actually take a record of the vote in the Senate. So it's 97-3. Indiana's then senators, Lugar and Coates, both vote aye. The three nays were interesting to me. Here you see Jesse Helms, and for those of you that can't remember Jesse, he was the literal embodiment of a very hard right conservative in the Senate, and Helms will have nothing to do with this. He says it muddies the First Amendment in an unnecessary way. The First Amendment speaks for itself. The Supreme Court is erred in this. In any event, they'll be vindicated. And the last thing that the Congress needs to do is start passing more laws when the First Amendment is enough. Harlan Matthews, I can't say he was a liberal. He was probably a conservative senator from Tennessee at that time. Very similar problems. And you have Robert Byrd, independent. Now, he caucused. He has always caucused with the Democrats in the Senate from West Virginia, and he votes no. So here you have this spectrum of nay votes that occur. So it goes back to the House, right? Because they've made minor changes. The bill has to go back to the House to recognize those changes. And again, they do this by voice vote. So Senate changes are accepted without modification. So they roll down, another voice vote, no vote recorded, and bang, it's done. And then President Clinton signs the act on November 16th, 1993. Now, the reason I point this out is that to show that this legislation sailed through in the same half of the congressional term that it started in. As a person who's been involved in government affairs for a long time, it is atypical for a bill to whoop through, and generally when they do, they tend to cause trouble. Here I'm thinking of Sarbanes-Oxley. Here I'm thinking of Dodd-Frank. Bills that just sail through. Now, this bill was short in the number of pages. Dodd-Frank certainly wasn't, and Sarbanes-Oxley wasn't. But nonetheless, this thing just whoops through. If you look at the picture here, that actually is a relatively svelte Teddy Kennedy standing right there behind the president. So now the Supreme Court, so 3 years go by before the Supreme Court takes its first test case. And this was involving a zoning dispute, if you will, with the Catholic Archbishop in San Antonio who'd applied for a building permit in a mission-style church in Bern. And it was located in a historic district. And those of you who live in towns or cities with historic districts, you know the drill, right? Good luck painting a shutter a different color. So you can only imagine how the city of Bern reacted, which was basically tell the Archbishop build someplace else. So he brings his case under RFRA, and he is claiming that this decision puts a substantial burden on the exercise of religion. So that's the test that RFRA laid out. In order for you to bring a claim, you have to show that you've been substantially burdened. And the word substantial modifying burden there is very important. I'll get to that a little bit later, but that is a very important modifying word on burden. It means you've got a really high bar to jump over. The state has to then turn around and execute and say that it has a compelling state interest. It has to articulate that, and then it has to show what it's doing is really the least it can do to affect that public policy. So City of Bern loses right off the bat at district court, but they prevail on appeal at the Fifth Circuit. So that is the point at which the Supreme Court picks it up. They've got two courts looking at the same set of facts, drawing opposite conclusions, and this is the one they want, and they take it. Unfortunately, it didn't necessarily clarify anything, but it certainly did create a call to action. So the Supreme Court finds for the City of Bern, and here's the interesting thing. They say, okay, the RFRA exists. We know Congress passed that. But in essence, the federal government cannot tell the states how to apply that law. So if you actually want to apply the law that Congress passed, states, individual states, have the responsibility for crafting their own legislation that marries up to the RFRA, that details out how their duties will be discharged. Now, I have to think if I'm a governor or I'm an attorney general in any state, I'm saying when this comes out, thanks a lot for nothing, guys, really. So majority, you see the majority there. Justice Kennedy writes the opinion, and O'Connor flips. Sandra Day O'Connor was on the court at that point. She flips out of the majority on the prior decision and writes this dissent. And quite frankly, the dissents are kind of technical. There's not any of that firebrand stuff that you saw from Brennan's. But at any rate, that's the decision. So states and judges then move into action. So this map you're seeing, and the colors are a little off because things have been moving rather quickly in the last couple of weeks, and I wasn't able to find something updated. But this is from the American Religious Freedom Ethics Public Policy Center. So you can see the color codes here. So with this darker green, states have enacted legislation, and then when you look at that lighter green, this is where the states have RFRA-like protections, because state courts have looked at the framework, if you will, within the RFRA, and they find that the framework has a lot to speak to it and benefit, which I would agree. Laying out the substantial burden test to be met, laying out the state's compelling interest, and then once those two are married up, then you need to sit down and weigh off the relative strength of either's argument, applying the federal government's duty, their requirement, to prove that to the extent that they are disrupting the individuals on religious interpretation of how they carry themselves, then the state's got to demonstrate that they do that too. So this is a very thoughtfully laid out process, and I'm unsurprised, quite frankly, that state judges started looking at that and say, yeah, that makes sense. And so you can see Indiana was in that spot. And this explains, if you hear people say, Kevin Brinegar, president of the Indiana State Chamber of Commerce, came out when this bill first started moving in the House and the Senate. There were two bills in the Indiana legislature. You heard Kevin Brinegar stepping up and saying, this is an unnecessary law. We don't really need it. And he's saying that because if these kinds of things had come up in Indiana, the likelihood that a state judge catching the case would apply the RFRA logic and test to it was extraordinarily high. So, but the way you have to think about it too, when you're a state, when you're a legislator or a governor, it's one thing to have state judges continuously deciding something, but at some point you do want your law to conform. You do want these things to be codified. You don't want to be under judicial restraint on these things. You want to codify your law accordingly. And so there was a mix, and we'll get to this in a minute, where states said, okay, fine, it's very clear where this train is headed. We'll knit this up properly in our legislatures. And so states starting doing that. So if you look here on the left, to keep score of what's been happening in this session across the nation. So Indiana passed the original version of RFRA 2 weeks ago. Indiana and Arkansas passed modified bills last week. Arkansas's modification was to basically pull everything out that didn't conform to the federal act, which and the federal act has already withstood, obviously, Supreme Court tests, so you're real safe doing that. So they did that. Mississippi passed in 2014. They show light green down there, but they actually do have an RFRA, so I want to make that very clear. Georgia is in their session right now, and their bill is in conference committee. Wyoming passed their bill out of the House, but the Senate committee that was supposed to get it didn't hear it. It came very late to them. I don't know the Wyoming Senate I don't know how they feel about that bill one way or the other, but I do know Wyoming, they have a very short session, and these people are come and gone pretty quick, and that may have been as much as timing as anything else. North Carolina's bill is out of both houses and is in conference committee also. So that's basically how this map looked rolling into this session. So what's the trend from my point of view. I think states will continue to establish their own RFRAs, and quite frankly, with every governor having a and legislature having a ringside seat of Indiana's trip to hell over the last couple of weeks, I think we'll keep that in mind as they modify and pass their ordinances. Judges have been and will continue to apply the framework. That's pretty clear. And I think that in the main, states are going to end up with the federal test on RFRA, whether they like it or not. And one way or the other, I think it ultimately becomes the law of the land in most every state, one way or another. And again, I'm talking about the federal version. So that's how I see the long-term trend of things. Although I will say that any state that hasn't already passed its own RFRA now would draw massive media attention to any type of bill. So we may see a quiet period here for a couple of sessions to let things die down. So the other thing I asked was, if so many states already have this, why is everybody screaming at us? And part of it, and Carl Ulrichs helped me with this, and I need to give a shout out to Carl as well as to Betty Lonis, two individuals who helped me with this presentation. Advance America is an outfit here active in Indiana, and this is what was posted on their website. Eric Miller, who you see is the founder and executive director, and he posted on his website. And another thing that happened is I started looking at this bill as everything flew off the handle. For the life of me, as I read through the bills, I could not find where it spoke to florists and wedding cake bakers. I couldn't find florists and wedding cake bakers anywhere in the law, so I couldn't imagine why people are screaming about it. And here's why. If you look at that site, Christian bakers, florists, photographers now be punished for refusing to participate in homosexual marriages. So that's when it actually connected with me. It wasn't in the law. It was people were pulling this literally off of the website, and that is what kicked things off in just a horrible fashion. So another thing that happened, and I got this from the Washington Post because to me this really speaks to it best of all, where this writer said Indiana backlash is a function of timing, and I think there's far more truth to that than not. And I'll also explain something that happened here with me also, and how I missed this brewing the way that I did. I don't normally end up in reactive phases in legislation, but I did this time. So if you look far to the left, the scale you have at the bottom, look at the bottom, 1993, federal RFRA passes, and Connecticut jumps out first. And everybody else kind of waits. It's pretty apparent to me for the inevitable first Supreme Court case to test that piece of new legislation. It comes out. The Supreme Court is crystal clear in Byrne. If you guys want to implement RFRA in your states and you want to carry out Congress's will, well, you have work to do. So now you see all of these states over the courses of their legislative sessions, everybody starts piling in and tending to their knitting, so to speak. Now you'll notice here when you get to 2003, 2004, you're starting to see this narrowing of the point between the support of gay marriage and the opposition to it. And Connecticut goes in and modifies its RFRA and now offers protections. They did not do it on gender identity at the time. They did do it on, pardon me, on sexual orientation. And so other states start moving, and then the Affordable Care Act starts getting debated and ultimately gets passed. And now all the cases start working their way through the district court. Sebelius v. Little Sisters of the Poor, Sebelius v. Conestoga Specialty Woods, Sebelius v. Hobby Lobby. And you can see the arguments that these lawyers are making, and they're bringing up RFRA. This is the lens through which I saw this and where I think a lot of these came out. Now, looking at this through the lens of the Affordable Care Act and the collision course that is set on religious grounds with the act, You know, you don't need a crystal ball for this, folks. You knew this was going to land in the Supreme Court. The religion issue with ACA was going to land in the Supreme Court no matter what. And as other states see this, they start saying, holy cow, we haven't done the RFRA. This is where this argument is going to be had, right? The Supreme Court is simply going to have to address the statutory language in the RFRA. So they start popping theirs in. So after Affordable Care Act is passed, you see everybody really hopping in line and getting their knitting done, so to speak. And Indiana is late to the game. And I think that I don't know. I'm speculating, but when I heard Governor Pence say at one point in this, well, this is something we should have done earlier, I genuinely think it was in this framework. But here's the problem, and this is how I missed it. I was looking at these circumstances through the lens of the Affordable Care Act. Society broadly, and everybody who blew up on this, wasn't looking at the Affordable Care Act. They were looking at it as an issue of rights around gay marriage, of rights around gender identity, of rights around sexual orientation. And through that lens, this looks terrible. It looks jarring. It looks completely out of kilter. And then when you compare it to last legislative session, around the legislation in defining marriage, if you're looking at it from that side of the equation, it looks to you like a pattern of assault. So I can completely get how one side saw this through one lens and how another side saw it through another. And generally speaking, when everybody is looking at the same set of facts and drawing completely different conclusions as to motive, as to why things are happening, you have a perfect recipe for a train wreck of an argument, and all of us got to see that happen at ground zero in Indianapolis. So let's look at Indiana's RFRA. So it takes the federal language and it applies the substantial burden test. Now the reason I point this out is not every state does that. As a matter of fact, Connecticut, whose governor saw fit to bar travel to Indiana, I don't know how many state employees of Connecticut travel in Indiana, but I'm sure some of them come, their state actually has a lower bar. There an individual needs only to be burdened, and so they actually have more stronger protections for religious observation in that state than Indiana does. It includes language of the compelling government interest. It includes the language as the least restrictive means, and so that whole balancing test, the instructions to the judge as to how to carry out this balancing test is all intact. What also remains is the definition of a person, right? So an individual, association, partnership, LLC, corporation, et cetera, et cetera, et cetera. This is consistent with 2 Supreme Court decisions, 4 appellate court decisions, and the opinion of the Obama administration's Justice Department in terms of the point of view that individuals do not totally surrender their First Amendment rights when they incorporate their interests. That in itself is not fatal to an advancement of a case, and so they've got that. So here's the fix. So first thing is I've done a bit.ly shortener here, so everybody that wants to grab that is where you can see the 4-page bill that was passed. The next shortener that you see there is for the modifying conference committee report that modified that act. So you really need both pieces in order to put the whole thing together. And here was the really material part. It's not that other material changes weren't made, and I strongly encourage you to read the legislation, but I can't do duty to it here in the time provided. But here's the big deal. They created this term called providers. So providers include both profit, not-for-profit, non-religious entities. So where they really drew the fence here is around religious entities. So if you are a provider, you may not offer religious observation as an affirmative defense or as an argument, and you may not discriminate, and you have no standing under the Act. So if you're out there basically doing commerce for all intents and purposes, this is what scotched you out. So when you think about all the things that you saw the company CEOs complaining about, this just basically stripped all that out of the act, put the religious organizations on the other side, and went from there. So what does this mean to us? Certainly we think, and on the HR side, a lot of us I'm sure went immediately to recruiting. Well, perhaps not immediately to recruiting, maybe the second thing to recruiting. And I've just got some bullet points here that I think make sense for me. Regardless of what you heard, nothing in the law sanctions discrimination, which is true. It does protect churches, religious, not-for-profit organizations, parochial schools, priests, rabbis, etc. Also true. I think it's very important for us to say we don't control state law. None of us do from where we sit, but our own policies, our own practices, our own values, that's what's important here. And many, many, many of us weren't drawing these distinctions to begin with. Right, so you're able to speak with great conviction on what you've done. Our profession, again, I can't emphasize enough. Certainly things have been crazy, and certainly things have been flying around, but we have deep experience in recruiting. And we've got decades of decisions. We got guidance from the EEOC, well, charitably, guidance from the EEOC, and support from SHRM. So we have got this. At the end of the day, our profession is best positioned in companies to meet this challenge. So let's look real quickly at typical RFRA cases, because I have to tell you the cases that were being surmised that would come up have no reflection of what's really going on. If you look at Indiana, one of the first cases we had was a Native American inmate up at Pendleton. And he said that his observation of faith required him to have a medicine bag that he wore around his neck under his shirt that contained within it certain sacred objects and items to his observation of faith. The prison said, no, you can hide weapons in that bag, and so we won't allow you to have it. We don't allow prisoners to be able to secret weapons on their persons under any circumstance. So that was picked up. Easy case to pick up. The state is with incarcerated individuals, the state is already in control of that person's life to an extraordinarily high degree. And so this case goes up, and so the judge gets it and applies the RFRA standard and says, okay, prison, you have a compelling interest, safety of inmates, safety of your employees, got that. And you have a religious interest, you want this medicine bag. So prison, state, can you go show me the type of weapons you confiscate? Let me have an idea of what these shivs and these weapons look like. And they showed him, and the judge noted that the length of these weapons were fairly common. And asked why, and they said, well, in order to do enough damage to internal organs, you need a certain amount of length in the weapon to be able to reach these internal organs, and there's bones and cartilage in the way and everything else. And he notices this length, so he goes to the Native American inmate and says, okay, if you had a medicine bag that was shorter in width and height than the weapon needed to create the requisite amount of damage to kill, could you live with that? And he says yes. And so this is a clear element of that balancing test to be applied. Sikh employee in IRS, I don't know how much people on the phone know about Sikhism, but like a lot of religions, it requires the individuals in that faith to carry certain items with them as an expression and observation of their faith. And with Sikhs, they carry a ceremonial knife, usually very, very small, called a kirpan. And this is, again, small, think in about as long as probably a nail file at the most. Nail file on a fingernail clipper is probably closer to the norm, and with the edge of a butter knife. And the Sikh employee wanted to carry that at work. IRS said, can't have weapons at work. That's a weapon. You can't bring it in. You can't do this. Well, this is observing my faith. And by the way, everybody's desk has pointy scissors with edges far sharper than my kirpan, and length of blades 4 times longer than mine. So you need to let me carry this. They went through a rigmarole, allowed the employee to work from home, and then conveniently fired them. They lost. A surprise. Santerre priest in Texas, Santerre religion, can at times periodically require the live sacrifice of animals, usually chickens or goats. And what had happened in Texas, they had a local ordinance, as a lot of localities do, that says people can't just kill four-legged animals out of hand. There are restrictions on this, and so he wanted to do that. They wouldn't let him. State of Texas lost. And last example, Muslim prisoner in Arkansas, he wanted to grow a beard. Unsurprising, anyone that is familiar with that faith and the requirement for males in that faith of observation. And the prison had a complete ban on beards of any kind. Every prisoner was to be clean shaven. And eventually they agreed on the length of a beard of 1 inch. That was insufficient in length to hide a weapon. I've learned in prison cases everything comes back to weapons. Everything comes back to weapons, unsurprisingly. And that's how the cases pretty much go. Generally speaking, I would say that the religious organizations, I researched these cases over the weekend. They seem to routinely lose zoning arguments. I also found that the Amish are like lifetime undefeated in ordinances that restrict their horse-drawn cartage from public roads. So this is a law that has been around for a long time. It has rich case law behind it. And that was one of the things that kind of surprised me as I did my research here. If you look in the actual cases of the actual application of laws that exist in actual states, you simply couldn't come up with evidence of things being enforced and decisions being made anywhere near as virulent as would be made out in Indiana. I also want to tell you that the cases where blatant discrimination has prevailed since RFR is passed is a big fat goose egg in the United States of America and its 50 states. So the way to stay updated, Mark had this slide up earlier, but you can see here we have lots of chapters across the state, easy way for people connected with fellow professionals and be able to see and hear presentations like this. I'm proud to say I'll be speaking at the Wabash Valley HR Association doing a legislative update on Wednesday. And so with Mark, do we have questions?
We have one so far, so go ahead and type your
Only one? Wow.
Only one so far. Question is, we are a library. We are a library. We have folks asking, does this law mean that employees can say, I don't have to look up information for patrons on abortion now that as this goes against my religion? Is this the case?
Okay. So relative to employment, so the first answer I will give of I am not an attorney. Okay. So when it comes to people carrying out and discharging their duties under the rules of an organization, that individual, the way this law is written now, I have a hard time seeing that individual having standing. They don't own the library. They're an employee of the library. The library is an employer at will, I assume. If not, and you have a different structure, then you can apply that. But those are the types of things that have always happened in HR. And no, I can't see anything in the law that creates standing for that individual. But I would seek counsel's advice on that before taking any action.
Second question, why do you think Pence didn't answer yes or no when George Stephanopoulos repeatedly asked him if the florist denied a gay couple services question?
I don't have a clue. I can tell you that I have rarely seen legislation move like this where I think all three parts were not on the same page on this. I don't think the executive office had clear insight into what was going on. If you look at the House version of the bill and compare it to the Senate version of the bill, the House language is very administrative. The House version of the bill reads like a standard piece of law, which is to say boring. It's straightforward. I read it for what it said, and there's no doubt it said what it said, but it did not have language in it that jumped out. If you looked at the Senate version of the bill, the application of the verbiage in it was jarring, specific, deliberate, written in a way I would call, quite frankly, in my experience, florid language for a piece of legislation. And so you have a scenario here where representatives in the House are saying, that doesn't look anything like the bill I voted for, which makes perfect sense to me. The House voted on their bill and sent it to the Senate, and trust me, in a session in which you're doing a budget, House representatives do not sit down and say, you know what, I have an extra 20 seconds here this session. I think I'll just go online and peruse Senate bills. They don't. They attend to that knitting when it comes to them. So you talk about the right hand not know what the left hand doing. The brain, the left hand, and the right hand didn't know what the hell was going on from my standpoint. But again, that's opinion, and I won't conjecture on what people in knowledge and direct knowledge knew and did with that information, whether that was right or wrong. I like that insight.
Okay. We've had a couple of people ask if we can get copies of the PowerPoints. I'm recording the thing, so you can have that, of course, but I assume Chris would be able to send the PowerPoint to me too, right?
Yes, I will after the session is over. Yep.
Okay.
And I put my contact info up too if people want to reach out to me, and certainly if you're in a chapter that's not yet scheduled me to speak yet this year, I still have a few open dates remaining. So have your program people contact me if they'd like to sign me up.
Okay. Next question, how will the amended law hold up to the purpose of using RFRA to protect against the ACA?
Well, that part's kind of been decided in the Hobby Lobby case. That was they applied the RFRA to that. They gave the protection to the Green family because Hobby Lobby was a closely held company. It's not a public company, and only family members own it, and there aren't tons of them. So I think that part is pretty much done. Where the ACA heads, I have utterly no clue. I have, no matter how much time and effort I put into this law, it seems like every time I turn around, an announcement comes out that upends it or changes some material component of it. But where we're headed, there are going to be arguments in states. I have no doubt in my mind that RFRA is going to come up in a state exchange type of issue. And state exchanges are probably where we're headed down the line, almost irregardless in my mind of the King decision.
Okay. Question, how did we get the 2 new protected classes?
Well, I don't know. That certainly wasn't where they started. If you look at how this bill started, it was clearly designed to carve out very specific protections for people observing their faith in commercial settings, and the fix completely flipped that. I've got to think here in terms especially of Eric Miller and anybody else on that side that was heavily influencing the Senate bill. I found no evidence of influence on the House bill, but certainly the folks that influenced that bill, they've got to feel a significant sense of loss here. They thought they had it won, and instead it went completely the opposite direction.
Got it. Okay. Why didn't Indiana draft a state law similar to federal law, since the amendment seems to read as the federal law is today?
Right. So a couple of things there. I'm glad to get that question. The state law reflected really 2 elements that I saw that were different than the RFRA, in that Indiana's definition of a person is clearly taken to show that Indiana recognizes again the appellate court decisions I referred to, the Hobby Lobby case. So Indiana's law done later reflects decisions that have been made, and so Indiana is actually an updated version in that regard. The element of protections, the other thing that came into it around commerce and things like that, largely came out of Texas's law. So, you know, if I were to look at this act and you ask me to apply percentages to it, I'd say like 95% of it was the federal law, 2.5% was the decision in Hobby Lobby, and 2.5% was Texas. So, which is not to say those 2.5% weren't seriously material elements. Don't get me wrong, but if you look at the parentage of kind of follow how this was constructed, that's kind of how it went. And so it's very normal, right? Legislation that happens later than other legislation will take what's happened in other areas into account.
Okay. A follow-up kind of to that. Can you clarify what you mean by sexual orientation and gender identity now being protected classes? Don't you mean only in locales that have those specific protections?
No, that is not what that act says. And again, I encourage you to read the act. That doesn't speak to locales. That says very bluntly that no one can discriminate on the basis of sexual orientation and gender identity. So sexual orientation meaning whether or not the individual prefers opposite gender or not. Gender identification means the perception of which gender the individual belongs to, irrespective of the gender that may be apparent or obvious when you look at them, or what their gender was at birth. So it's the best I can do on a gender identity description at this point. But no, it does not require locales to create their own ordinances. Now I want to however, make this very, very clear. This is in the area of employment, right? So the issue can be broader than this, but this identifies this affects terms and conditions of employment. That's why this is a big deal to us. Anytime a new protected class is ordered, created under terms and conditions of employment, that's a big deal to us.
Okay. How does the Indiana definition of exercise of religion, broad with inclusion of non-central beliefs, compare with other state RFRA definitions, and how will you see that playing out? This is from an attorney, by the way.
Yeah, I was going to say that's an easy answer. I don't know. I was going to say it's the easiest question I've gotten so far. I don't know.
Okay. Does the law apply to all Indiana employers, even with those who have a religious affiliation?
Right. So as you look at the carve out, the difference between that distinction between providers and persons, that carve out appears to me to go to great length to wall off religious institutions, religious-based not-for-profits, parochial schools. I encourage everyone to look at that committee modifying report, and you'll see that really jump out.
Okay. Someone says, I'm reading right now that the fix does not address health care and education. Example, a private pharmacist could still cite their personal religious beliefs as a reason for denying HIV meds, fertility drugs for lesbian couples, etc.
Right. And so we've had this one for a long, long time. Especially around the issues of pharmacists, I think I have seen a bill in the Indiana legislature around pharmacists dispensing everything, dispensing birth control, dispensing Plan B, you name it. And there have been bills, more sessions than not, over the last decade that work to carve that out. None of those bills have ever made it. I'm not even sure one has made it to a committee hearing. I suppose it's possible in the past decade that one of them had, but certainly one's not made it out of committee and one's not gone to the floor.
Okay. Should we now change our printed policies to add two new protective classes?
Yeah. I do know a lot of attorneys got really good at this a few years ago, and I've seen more than a few handbooks in my personal practice as a consultant where attorneys have drafted language to lay out protections and then put a tagline on that says, as well as any protected classes that may be established by, legally at a future date. So protected classes are protected classes, but you might want to actually articulate that kind of statement. Again, I think a lot of employers have gone to great lengths in past years to eliminate barriers to attracting and retaining talent. So depending upon where you are, you may be way far down the road on this here, and you may not require a lot of modification.
Okay.
But I'm sure attorneys will be calling all their clients and sending them emails as we speak.
Yep. By the way, all of our certification numbers are in the chat window if you want to write those down. Two more questions. In the wake of all the problems that Indiana has had with passing RFRA, do you see other states reviewing their laws to review?
Sure. Yeah. I absolutely expect that. Well, first of all, anybody that doesn't have to touch their law, I think won't for a while. I expect this to influence North Carolina. I expect this to influence Georgia. Again, they're all in process, right? You saw how it influenced. You saw how it influenced Arkansas. Asa Hutchinson, the governor of Arkansas, said very clearly communicated to his legislature. At least to me, it's apparent that he did. He didn't tell me whether he did or not, but it's pretty apparent. I can read between the lines that said, "Look, guys, the federal law we know is battle tested. It stands legal scrutiny. You just pass that federal law and let's put this behind us." And quite frankly, I would be stunned if Georgia and North Carolina don't do the same thing.
Okay. Can we still require a caregiver to escort a client to the client's, in parentheses, church service? We don't require they participate in the service, but they have the option of switching shifts with a coworker.
Yeah. So then typically that will go to the again to the terms and conditions and the employer, because you're just asking the individual to provide conveyance, right, to various locations. I'd have a hard time seeing an individual saying that they couldn't do their job because they had to take someone from point A to point B to the point that's being made. You're not asking to participate and share in that in any way. So again, I reinforce and will say again, I'm not an attorney. I did not go to law school. I have not passed the bar, but I've been practicing HR for 27 years, and I'm pretty clear how that conversation would go if I were in HR in that company.
Mm-hmm. And we have a follow-up to the previous question. Just to clarify, sexual orientation and gender identity are protected classes in Indiana, and not
with
only,
regards to employment, yes.
And not only as it relates to this bill.
This bill is what creates it. It's the vehicle for it.
Okay.
Yeah. And that's where I said, this is, you wouldn't expect new protected classes to come out of this sort of vehicle. I think that's what is kind of puzzling. Where we started and where we landed are in for different time zones or different date lines as far as legislation goes. I mean, that to me is the thing that's why I made the statement at the beginning. If you told me when this session started that creation of new protected classes for purposes of term and conditional employment would have been on the table and that I'd be having this conversation, I would put a lot of money on the table saying that wouldn't happen.
Gotcha. And I think that's it.
Wow. Okay. Good.
And we're right at the hour, so that's
excellent. Stuck the landing. Okay. Well, this is going to be saved, as Mark said, on the State Council website here, probably within a couple of hours. I made these slides text-rich for a reason. I usually don't like to do this when I'm speaking, but I think the text is what people are going to need to be able to read through it, think through it, and quite frankly, be able to do your own research and come to your own conclusions about this. So thank you, Mark, so much for moderating this for me, and I hope everybody has a great day.
No problem. And again, the certifications are in your chat window. If you need something else, I can send that to you. No problem at all. But this has been a great session and very clarified a lot of things for me as well. And we thank you, Chris, and everybody have a great day.